I'm going to give a pitch for 1 second about our digital asset practice at Willkie, and then we're going to talk about legislation. So Willkie Digital Works is Willkie Farr and Gallagher's digital asset legal practice. It's an interdisciplinary group of about 40 lawyers. We offer what we think is a cutting-edge understanding of the digital assets markets and their regulation, along with the resources and judgment of a traditional law firm. We do transactional work. We advise on the slew of regulatory issues in crypto, including securities, commodities, banking laws, AML and KYC considerations, intellectual property, privacy, cybersecurity, tax, others that I've not deliberately left out. I co-head the group along with my colleague and former CFTC Chair, Chris Giancarlo, who you heard from this morning. And I'm pleased to be with two other great colleagues today, who we briefly introduced a second ago, Neal Kumar, partner in our Washington office, who focuses on commodities and derivatives laws and digital asset matters in those spaces, and Mike Selig, counsel in our New York office, who joined us recently and whose practice includes a huge variety of areas within digital assets and crypto. So one of the things—
He's also got really cool Bitcoin socks.
He does.
I just got a hot spotlight.
He's got the best socks. Yeah, but their price went down, didn't it, in the last? One of the things we do, maybe not surprisingly, is follow legislation in this area, and that's what we want to discuss today. The recently introduced Lummis-Gillibrand bill has been top of mind for many of us in recent weeks. This is a proposal that addresses comprehensively many of the foremost topics in this area currently, including CFTC versus SEC jurisdiction, which we're going to focus on in a minute, stablecoins, which we'll also focus on, consumer disclosure, energy consumption, the possible development of a self-regulatory organization, cybersecurity, regulatory sandboxes, tax, the use of crypto in retirement savings, SEC custody rules, and more. A proposed bill, as you may know, is also expected to be forthcoming from Senators Stabenow and Bozeman, so we're following that very closely as well. So, Neal, what about SEC versus CFTC in this bill?
Sure, and I think before we get into the sort of depths of the legislation, it's important to remind folks and to highlight that we are far closer to the beginning of the legislative process on this topic than we are to the end. And I think there may be certain topics that get peeled off, some narrower issues like stablecoins that may get addressed in this legislative session, but the odds are we're talking about next year, and the Lummis and Gillibrand bill, while impressive and thought-provoking and very comprehensive, probably are the starting point of planting a flag and beginning discussions between legislators. And so we're in for a long ride and a fun ride. Probably the biggest winner out of the jurisdictional battle, or at least initially, and I think this is something Mike and I were talking about before we started, that the clarity is it felt clearer when it first came out, and I feel like we're going to continue to having debates about jurisdiction, but seemingly the biggest winner was the CFTC. And I think before I mention what they got, it's important to talk about what they had before. And so for those who aren't familiar, CFTC has complete exclusive regulatory jurisdiction over the derivatives market, so futures and swaps. That exclusive jurisdiction clause is fairly rare within regulatory agencies, but it's something that's been a part of the CFTC since 1922, starting with futures and then in 2010 with Dodd-Frank and swaps. So what Congress would do is take that exclusive jurisdiction and expand it to include digital assets that are commodities. And historically, the CFTC has only had anti-fraud and anti-manipulation jurisdiction over the underlying commodity. So they'd regulate the futures market, they'd regulate the swaps market, and then they'd be able to pursue fraud and manipulation in the spot markets. And now for digital assets and digital assets alone, so they wouldn't be able to get jurisdiction over the underlying crude markets or metals markets, but for digital assets, they would get the ability to regulate them. There's a new registrant, which is fairly interesting, a digital asset exchange. It's a permissive regulatory regime, which is somewhat unique within the CFTC. So you don't have to register as a digital asset exchange. There are some benefits to doing so. And the main benefit is that a futures commission merchant or an FCM cannot trade on a spot exchange, at least under the Lummis bill, unless that that spot exchange is registered as a digital asset exchange. So the Lummis bill has some carrots in there. Legislation has sticks and carrots. I think this one is you'll register, you'll have to comply with a number of core principles, which for those who practice in this space have seen at DCMs or designated contract markets, which are futures exchanges. So they plop those on top of the digital asset exchanges. And so there is a regulatory regime that we put in place. Again, it's permissive, so it's a little unclear as to if this bill were to become law, how it would shake out over time. But that's a hallmark of the CFTC's jurisdiction. Again, you get expansion into the spot markets, and you get a main new registration category that is a digital asset exchange.
Terrific. That's great. I just want to mention one other category within the bill and then turn things over to Mike for some further thoughts. Stable coins have been, of course, so much in the news recently, and there are, not surprisingly, pretty comprehensive stablecoin related aspects to this legislation, including one-to-one coin versus USD redemption requirements, reserve requirements, including types of assets that can be in a reserve, disclosure requirements, and then the possibility of a depository institution charter, although those of us who are looking at the depository institution provisions are still sort of sorting out the interplay between what a depository institution versus non-depository would have to do under this legislation or could do. I wanted to note in that regard also that some similar requirements are already going to kick in New York under New York State Department of Financial Services guidelines on stablecoin that were issued last week, which similarly provide one-to-one redemption requirements, reserve composition requirements, systems requirements in the case of those so-called guidelines, and attestation requirements that read to me to be even a little stiffer than just the disclosure requirements in the proposed federal legislation. And these requirements would, again, styled as guidelines, but really requirements would apply to any stablecoin issuer that holds a New York BitLicense or a New York limited purpose trust company charter. So that's something that'll, kick in before we know really what's going to happen on the federal side.
Yeah, and the other regulator in the room, Neal mentioned the CFTC, but the SEC has really had a dog in this fight since the beginning. The Howey test, which is a test for determining whether an instrument is an investment contract, which is a type of security, has really been the test used by the SEC to assess different types of digital assets and determine whether they fit within the bucket of securities. The Howey test is an investment of money in a common enterprise with a reasonable expectation of profits derived from the entrepreneurial or managerial efforts of others. The Lummis bill is trying to kind of carve out the asset itself, the underlying asset that's delivered in some of these transactions from the contract. So the actual definition of a security includes a contract, scheme, or arrangement. And so what the bill is trying to clarify is that the underlying asset, which they call ancillary assets, are commodities, and the actual contract or scheme or arrangement, that itself is the security. And so carving out the underlying assets that are delivered and putting them within the CFTC's regulatory purview as opposed to the SEC, except in the case where the actual ancillary asset would be essentially a debt or a security, an equity instrument. But the question of whether this will really take away the power that the SEC has under the Howey investment contract scheme, which comes from a 1946 Supreme Court case, is unclear. There have been comments raised around the SEC's ability to still challenge a lot of these determinations made by issuers that it's an ancillary asset and not a security, even though the legislation kind of tries to carve these assets out. There's a lot of ambiguity there. So it remains to be seen where this will net out. There's also this idea that issuers of investment contracts, right? So the actual contract itself, whether it's a SAFT or a token warrant or a token rights agreement, that itself would be the security, and there would be disclosure obligations that would be ongoing. So for so long as the token is trading on spot markets and there's a $5 million volume of trading, or there's entrepreneurial or managerial efforts exercised by the issuer of the token with respect to the token, these disclosure obligations would be ongoing and the company would have to continue to make those on a yearly basis. The query whether how this would really work if, for example, the SAFT agreement or the token rights agreement expires or terminates, but the tokens themselves are still floating around as non-securities. The disclosure obligation would not necessarily be with respect to any sort of security that's on the market. The actual holders of the ancillary assets would essentially be safe harbored, but the issuer of the token would still have to make those obligations to not have to comply with securities law with respect to the tokens. So lots to be worked out there. It's not all clear as it should be.
Yeah, I think we all sort of saw the ancillary assets provision in the Lummis bill and somewhat celebrated. And as you read it more carefully, you realize that what Congress is doing is codifying the Howey test into a federal law, and then that leaves a lot of power within the remit of the SEC to continue to apply the Howey test as they wish. And so we've all seen how that played out over the past several years. And so the idea that the CFTC, I mentioned before, a apparent big winner, but I don't think it's a clear-cut big winner, and I don't think it's very obvious that, again, we've got a lot of issues to work through as we get through the legislative session. And, a query as to whether it's even solved in Congress or whether or not you get a bill that's passed and then the agencies can continue to fight it out as to who holds what.
Well, we were allotted 10 minutes, and we've probably used that up. 10 minutes goes incredibly quickly, but if there is a minute for us to take questions, we'd be glad to do that.
Yeah, real quick one question. Great job, guys. So it sounds like you're saying is with the bill, is they're trying to delineate. Oh, sorry. It sounds like we're trying to say with the bill is they're trying to delineate the asset itself is the commodity, and the contract is the security. Well, you think that'll fly?
It's hard to say because there's still a relationship potentially with respect to the holder of the asset and the issuer of the asset. And so if the SEC and federal courts view these actual tokens floating around as relationships, agreements, arrangements between an issuer and a holder, there's still an argument to me that there's some sort of investment contract. But generally the case law supports this idea that that the oranges in the Howey case were not securities themselves. It was the kind of scheme around the land sale contract and the management contract that created that relationship. And so it is supported in the case law, and really this is just a clarification, as Neal said. But in some cases, there's certainly going to be an argument to be made that the token itself, especially like a pre-functional token, there's certain expectations and relationships in place.